Hello, aspirants. A very good morning. Welcome to Pragna IAS Academy. As a part of our current affairs session, 1st August 2024, a detailed news analysis is being provided and it will be benefited to a fresh aspirant to a senior most level aspirant. And as a part of that, the first important current affair is Prohibition of Unlawful Conversion of Religious Bill 2024, which is very much important for our GS paper 2. So let us discuss what exactly these were. Okay, so here comes the point. As a part of this current affair, we are going to discuss what is anti-conversion law. What is the need for this law? And what are the issues associated with anti-conversion laws? Okay, these will be our primary focus as a part of this current affair. And we all know that anti-conversion laws passed in number of states but are being scrutinized because of their ambiguity and the absence of strong justifications for them. The Indian Constitution guarantee of fundamental rights is seriously threatened by the vague terms which are being using in these anti-conversion laws. People convert to a different religion for various reasons, as we all know. And this word conversion can be seen by free choice, as according to the Indian Constitution. And as a matter of this free choice, you should understand this active conversion by free choice is due to a change in beliefs or secondary conversion, deathbed conversion, conversion for convenience, marital conversion, and forced conversion. These are the types of conversions. Saying or talking about these types of conversions, you should also remember a point here. This anti-conversion law refers to the laws that are designated to prevent or to prohibit the conversion of one religion to another. Okay, and that is where the complete context is coming into picture. So when we are saying what are anti-conversion laws, then we can say what? Anti-conversion laws are those laws either to prevent or to prohibit the conversion of one religion to other. And these laws are those laws may be used to prevent individuals from leaving a particular religion or groups from recruiting the members from other religious groups. So this is the topic. What is anti-conversion law? And the specific provisions of anti-conversion laws vary from place to place, state to state, and may be enforced through criminal or civil penalties as well. And in some cases, anti-conversion laws are used to protect the dominant religion in a particular society or to suppress the minority religions. Some people believe that anti-conversion laws violate the right to freedom of religion under Article 25, which is protected even by the International Human Rights Clause. And coming to the second important question here, what is the need for this law? There are n number of variety of reasons why some people or organizations may advocate for anti-conversion laws. Some people believe that these laws are necessary to protect the cultural, and social cohesion of a particular community or society. They may argue that conversion from one religion to another religion can create conflicts and divisions within a community, and that anti-conversion laws are needed to prevent such conflicts. And others may view anti-conversion laws as a way to protect the traditions and beliefs of a particular religion and to prevent the erosion of its influence or power. Some may also argue that anti-conversion laws are necessary to protect the individuals from being coerced or deceived into converting to a different religion. And they may claim that some religious groups use manipulative or unethical tactics to recruit the members, and that anti-conversion laws are needed to prevent such abuses. So these are the certain arguments which we can come across. And as a part of that, you should recollect the point to this 1st August 2024 current affair. There is a connecting dot on July 4th, 2024, which is Allahabad High Court on religious conversions. And the source is the Hindu. Okay. So what is this? Why this is in news? What is the reason for this? So here comes the reasons. The Allahabad High Court addressed the issue of religious conversions in India, highlighting the potential demographic impact on the majority population. So, religious conversions is tending to result in what? It is going to impact the demographic impact on majorities. This is the statement used by Allahabad High Court. And these remarks, while rejecting the bail application of an individual booked under Uttar Pradesh Prohibition, Unlawful Conversion of Religious Act 2021. So, what is the backdrop of this in the sense? The backdrop is very clear that an individual was booked under Uttar Pradesh Prohibition of Unlawful Conversion of Religion Act of 2021, and kidnapping or abduction with intent secretly and wrongfully to confine a person of the Indian Penal Code. So this case underscores the court stance on the constitutional boundaries of religious propagation and the urgent need to curb the unlawful conversion activities. And the Allahabad High Court observations on religious conversions were like, the Allahabad High Court clearly stated that Article 25 of Indian Constitution guarantees the freedom of religion, but it does not provide for conversions, but allows for the propagation of religion. So what you should understand here, it is very clear that it is freedom of choice and propagation is allowed, but not conversions. So this is where the points were. Okay, this is where the points were. So conversions were not allowed is the point. The court clearly clarified that propagation means promote a religion, but not converting individuals from one religion to another religion. And the court expressed concern if such conversions continue to unchecked, the majority population in India could become a minority, and stressed the need to prevent the majority population from potentially becoming a minority due to these conversions. The court noted that unlawful conversions, particularly targeting SCs and STs and economically disadvantaged individuals, is a rampant pace throughout the Uttar Pradesh. It is being going on like anything as a great campaign in a disastrous way in Uttar Pradesh. And the court recommended the religious congregations where conversions are taking place should be immediately stopped. And in this context, we as an aspirant should understand what are the key Indian constitutional provisions with respect to religious conversion. With respect to religious conversion. And here comes the points which are important for the examination. One is Article 25, which guarantees the freedom of conscience and the right to freely profess, practice, propagate the religion, and it is subjected to public order, morality, and health. And the state can regulate or restrict any economic, financial, political, or other secular activity associated with religious practice, which means it allows for the regulation of secular activities associated with religious practice and throwing open of Hindu religious institutions to all classes and sections of Hindus. Likewise, Article 26 is the second important Indian constitution provision, which entitles every religious denomination to manage its own religious affairs, again subject to public order, morality, and health. Likewise, Articles 27 to 30 guarantee freedom to manage religious affairs, contribute monetarily to any religion, and set up and administer the educational institutions. And all these can be seen as a part of this. Along with this, you can also say the main important current affair here. The main important current affair here, it is nothing but Uttar Pradesh Prohibition of Unlawful Conversion of Religion Act of 2021. Actually, this act aims to regulate religious conversions and prohibit, clearly it prohibits conversions achieved by misinterpretation, force, undue influence, coercion, allurement, or by any fraudulent means. And illegal conversion carries stand of punishment of 1 to 5 years, 1 to 5 years of imprisonment with a minimum fine of 15 years. So, an FIR for illegal conversion is 1 to 5 years of imprisonment with a penalty of 15,000 rupees. And this punishment can be enhanced to 2 to 10 years, 2 to 10 years with a minimum fine of 25,000 applies if the victim is a woman, if the victim is a woman or a minor or belongs to SC or ST category. And in mass conversions, a punishment of 3 to 10 years with a fine up to minimum of 50,000 rupees. And if you are repeating the offenses, the offenders may face up to double the relevant punishment. And any marriage conducted for the purpose of unlawful conversion is declared void. So this is the new act which was passed by Uttar Pradesh government. and it is only limited to Uttar Pradesh itself. And in this context, you should understand certain important points which you need to prepare certain important notes, like what are the Supreme Court interpretations on religious conversions. Okay, and here comes Stanislaus versus State of Madhya Pradesh of 1977, where the Supreme Court upheld the anti-conversion laws, and it clearly stated 25 clause 1, article 25 clause 1 of Indian Constitution does not grant the right to convert others, but rather the right to transmit or spread or propagate or promote one's religion as according to the principles laid down. It was clearly mentioned it is not a right to convert. It is a right to promote, right to propagate. And the second important case, Sarla Mugdal case versus Union of India, 1995. Okay. Likewise, a correlated case, Lily Thomas case versus Union of India 2000. In these two cases, the Supreme Court held that conversions to Islam solely for practicing polygamy were invalid. Means what? With an intention to convert into Islam, marrying the partner is invalid. It is not going to be valid as a rightful, legitimate marriage. So, in these two judgments, the Supreme Court stated the same. Likewise, M. Chandra versus M. Tangamuttu and another. This is the case in 2010. The Supreme Court established the need for evidence of both conversion and acceptance in the new community. So, in this case, it was very clear evidence of both conversion and acceptance is mandatory. It is very, very important. You should produce the evidence saying why you are converting, what is the reason for conversion, everything will be taken into consideration. Not only that, Graham Stein's case of 2011. Here, Supreme Court stated that there is no justification for converting someone through force, provocation, and incitement, which means what? Conversion through force, provocation, incitement are not valid. This is not justified. It is not correct. It is affecting the core fundamental rights spirit of Indian Constitution. Likewise, very, very important case after Sarla Mugdal case for the examination point of view, right to privacy case of 2017. The Supreme Court emphasized the constitutional right to freedom of religion, including the ability to choose and express faith, asserting that state interference must be proportionate. So, even though till now the above cases which we have discussed are clearly saying forcible conversions or converting is not a right, okay, under the fundamental rights article 21, but here in this case what it is saying, on the other side it emphasized that article 25 is a constitutional right to freedom of religion, including the ability to choose. So an individual citizen was ensured that the ability to choose, means personal choice, is to be ensured. To express faith and assert that state interference must be proportionate. So until and unless if there is a need, a demand for the state interference, the state should not interfere. So this is what right to privacy case of 2017. But You know what? You know what? Yet the Supreme Court has to provide a definite ruling on the legal interpretation of propagate, the word propagate under Article 25. We are eagerly waiting for that. And this really attained the interest of the nation. The complete nation is looking towards the Supreme Court, eagerly waiting for the interpretation of the Supreme Court to the word propagate under Article 25. So you please do understand that anti-conversion laws in India are the regulations, okay, are the regulations to seek to prevent individuals from converting one religion to another, especially through the means of force, fraud, inducement or allurement. And these laws aims to ensure the religious conversions are voluntary and not coerced, not forced, so that they can protect the individuals from being pressured or misled into changing their faith. And it is not new to India. You please do understand even that. Okay. It is not new to India. Okay. Why? In the sense, under the pre-independence era, before India gained independence, several princely states enacted these type of laws. Okay. Under the pre-independence era, several princely states enacted anti-conversion laws, especially with an aim and objective to restrict the missionary activities and conversions to Christianity. Okay, like the way the best examples were Raigar State Conversion Act of 1936, Patna Freedom of Religion Act of 1942, Sarguja State Apostasy Act of 1945, Udaipur State Anti-Conversion Act of 1946. Likewise, right from pre-independence era, in order to not to force the people to convert into Christianity and to restrict missionary activities, these were the things. Not only that, immediately after independence, post-independence, the same was continued. The efforts to pass central legislation on religious conversion have repeatedly failed, of course. In other words, to say, in 1954, Indian conversion regulation and registration is a bill, okay, where backward communities, likewise, backward communities, religious protection bill, religious protection bill of 1960. Likewise, another effort, All India Freedom of Religion Bill of 1978. Okay, these are the central legislative bills. Okay, in the central legislature, means in the Parliament of India, these were introduced but failed. Despite these failures, okay, despite these failures, several states have enacted their own anti-conversion laws over the years. Okay, in which the first state was Odisha to enact this in 1964, restricting the religious conversions, prohibiting forceful conversions and fraudulent means. Next is Madhya Pradesh in 1968. introduced the Madhya Pradesh Dharma Swatantraya Abhinayam, requiring the notification to the district magistrate for any conversion activities under the penalty of law. Likewise, Arunachal Pradesh in the year 1978, Gujarat in the year 2003, Chhattisgarh in the year 2000 and amended in the year 2006, Rajasthan in 2006 and amended in the year 2008, Himachal Pradesh 2006 and amended in the year 2019, Tamil Nadu in 2002 to 2004. Okay. Likewise, Jharkhand in 2017, Uttarakhand in 2018, Uttar Pradesh in 2021, and Haryana in 2022. So these states have enacted laws prohibiting various forms of religious conversions with enhanced penalties for conversions involving SCs, STs, minorities, and women. Okay. And what is the controversy now with this bill? There are certain things, but before that, please do remember the Union Ministry of Home Affairs stated in an affidavit to the Supreme Court that the right to religion does not include the right to convert others, especially through fraudulent or coercive means. And the Ministry of Home Affairs referred to the Supreme Court the interpretation of Article 25 and emphasized the fraudulent conversion affects an individual freedom of conscience and can disrupt the public order, means affecting the fundamental right 25 clause 1. And the center has not clarified if it will introduce a special law or religious conversions as requested in the petition. That is where the point is. We are eagerly waiting on one side the Supreme Court to interpret word propagation under 25 articles. On another side, we are also eagerly waiting that the Parliament's decision over this. Okay. But why this is in news in the sense? Because of the challenges related to this anti-conversion laws. Okay. The challenges related to anti-conversion laws, like the constitutional concerns. The constitutional concerns. The primary challenge to anti-conversion laws in India revolves around the constitutionality, particularly with respect to fundamental rights, where the critics argue that these anti-conversion laws are infringe upon the rights of freedom of expression under 19th article, freedom of religion under 25th article, and freedom to privacy under 21st article. So what are the articles involved here? 19, 21 and 25 articles of Indian Constitution are getting affected. This is what the critics point of view. And in 2012, the Himachal Pradesh High Court ruled certain provisions of the state's Himachal Pradesh in which year? 2006. Yes or no? So in 2006. So with respect to that, the High Court of Himachal Pradesh, Honorable High Court of Himachal Pradesh, clearly stated that anti-conversion law was unconstitutional. It upheld right to privacy, stating that requirement of giving a month's notice to the district magistrate violated this right. Not only that, in 2021, the Honorable High Court of Gujarat stayed the provisions of Gujarat Freedom of Religion Act, which is an anti-conversion law act of 2003, which were amended to include marriage as grounds of prohibiting conversions. And here you should remember the court upheld the right to choice of an individual, stating that the act of the Gujarat gave the impression that interfaith marriages followed by conversion could be deemed illegal. So likewise, there are n number of constitutional concerns with respect to this. Likewise, there is another challenge, burden of proof. Anti-conversion laws often shift the burden of proof. on to accused to demonstrate that conversions were not carried out through prohibited means. Not only that, it is going to impact on interfaith marriages, whereas the recent state law of the Uttar Pradesh especially declare that marriages are void, null, if they involve conversion solely for the purpose of marriage. But the critics use it to argue that these provisions interfere with individuals' rights to freely marry and choose life partners regardless of religious differences, which is a matter of personal choice, which is under 19th and 21st articles. Okay, not only that, these anti-conversion laws might be seen as the allegations of misuse and targeting and targeting. And hence, the critics argue that the anti-conversion laws are often misused to target the religious minorities, especially Muslims in this country, and dissenting the voices, leading to the concerns about their exacerbating communal tensions and discriminating against vulnerable groups such as Dalits, Adivasis, and women. So these are the important challenges as a part of this. So what to do now? What to do now under this so-called Uttar Pradesh anti-conversion law? You should understand. Okay, that there are certain major changes have been suggested as the maximum punishment from 10 years to life imprisonment, allowing anyone to file a complaint and making bail more challenging. Okay, and more importantly, if you could observe here, the district magistrate, okay, yes, the district magistrate will attach a copy of the second declaration. So first and second declare, first by the person who want to convert into another religion, second by the district magistrate, and a notice board. On the notice board that the second declaration will be made available, and anyone can register any objections to the conversion that may have them after it got submitted, which means what? It is not going to be deemed as a personal choice. Someone is coming and affecting our personal choice, our privacy under 19, 21 and 25 is clearly evident through this act, is the point. Is that clear? And hence you should understand there is certain ambiguity in the definitions itself. Like the words which were used, fraud, coercion, allurement, are not interpreted by making all the people to participate. Arbitrarily, it was interpreted and hence used against law enforcement. Okay, and it is going to affect especially the Hindu-Muslim relationships, rising for communal tensions, and it is furthermore deterrent for the social polarization as well. It heightened the social unrest, religious polarization, which finally again directly proportional to the communal tensions which are already existing in this country. But there are also certain arguments in support of this law where through this law they can prevent the forced conversions, they can preserve the social harmony within the community so that the conflicts between the religious communities can be avoided. In these regulations, through these regulations that the religious conversions can be regulated, the deterrence against the conversion rackets with a personal financial gain can be regulated. Promotion of religious freedom with responsibility can also be promoted. Okay, religious liberty can be restored as it is ensured by the Constitution under Article 25. And the support from public opinion was also gathered, and hence sizable segment of the population in Uttar Pradesh are very much happy because to end the disputes over the religious conversions. So this is what exactly the points were, and hence you should also understand what as of now can be made possible. In other words, to say, what is that way forward that we can to establish a clear and unambiguous definitions for the vague terms like force, allurement, coercion in these anti-conversion laws. Ensure that these anti-conversion laws uphold the principle of presumption of innocence. Uniform set of regulations across the states to avoid confusion and potential misuse. And more importantly, a national framework. A national framework is the call of the hour on religious conversions that respects the individual freedoms while safeguarding against coercion. So this could offer more uniformity and potentially prevent the misuse of the state level. Encourage the interfaith dialogue programs, educational initiatives, cultural fests to foster understanding and respect between the religious groups is the call of the hour. So this is what the complete points related to this current affair, and based on this, try to answer this question. Consider the following statement regarding freedom of religion in India. Yes, freedom of religion under 25 is guaranteed for both citizens and non-citizens of India. Okay, and hence you can say that first statement is correct and outlined are contingent. Yes, these are the reasonable restrictions. What? Public health, morality, and public order, and hence both are correct. And hence your answer is C, both 1 and 2. Okay, and here comes a mains model question which is provided by our Pragna Institute. You people, after going across the concept, after understanding, interpret by your own and try to answer this question. So here we have given that the support, how to write a question, what is the key demand of the question, okay, the structure of the question to be followed and all. So just go through those. Okay,